Hello, my name is Ira Smith, and I am a licensed Insolvency Trustee in Toronto. First, I hope that you and your family are safe and healthy. Ira SmithTrustee and Receiver Inc. is open and fully operational. We are doing all consultations and all meetings, either by telephone or video meeting, are available to answer any questions that you may have. Brandon wrote the blog for today on a very interesting matter. And what it is two bankruptcy cases out of the United States and how the COVID-19 pandemic gave them an opportunity for a very novel and creative use of the restructuring statute. And then he explains how that quite possibly could also be used in a Canadian corporate restructuring. So in the United States, last March, Modell's Sporting Goods, which is the largest family-owned retail sporting goods chain in the United States, filed under Chapter 11 bankruptcy protection. They then, in late March, went to court with a motion which the court granted. And that motion was to have a suspension in both the bankruptcy administration and in the operational running of the company because of the fact that all the stores had to be closed because of the COVID-19 pandemic. Modell's gave to the court a modified budget and showed all the expenditures that they're supposed to pay and then divided them up between those that they would pay and those that they would not pay. And the ones they would not pay included rent on all of their retail locations. The reason being that the locations are all closed. They could not carry on a liquidation sale. They could not earn revenue. And their ability to look for an investor or purchaser in the company was also thwarted because of this. And the court approved it. They gave them both a bankruptcy suspension and an operational suspension. The suspension goes until the end of April, but the court also said that Modell's can continue coming back to court, updating the information, and getting these suspensions extended. The stay of proceedings is in place, so no creditor, including landlords, can upset the apple cart. The second case is that of Pier 1, the household furniture retailer. They filed for bankruptcy in February of this year. Again, Chapter 11 bankruptcy protection restructuring. They borrowed a page out of the Modell's playbook, and in early April, they went to court and got the same relief. They do not have to pay their rent. Now, you've already read in the newspaper and heard in the media that Canadian companies have already gone to their landlords and said, we have to close down. We're not earning any money from the stores. We're not paying commercial rent. And right now, landlords seem to be working with their tenants. But what if a landlord gets overly aggressive and unreasonable and threatens the tenants with actions such as distraint or termination of the lease? The landlord doesn't have to go to court to get either of those remedies. But the tenants certainly would have to go to court to try to prevent the landlord from doing that. And the courts right now are closed and only dealing with emergency situations. Whether the court thinks that would be an emergency or not, I don't know. I better turn my phone off. But the insolvency legislation in Canada could be used, and I'll explain why. The two insolvency statutes in Canada, restructuring, is Part 3, Division 1 of the Bankruptcy and Insolvency Act, and also the Companies Creditors Arrangement Act. The differences between the two are a subject for a different blog. But for now, just understand that either one, depending on the circumstances, can be used for a corporate restructuring. The Bankruptcy and Insolvency Act gives the judges hearing a bankruptcy matter wide latitude in the kinds of orders a judge can make. And certainly it is within the judge's ability to make an order under unusual circumstances like we're in now, that if the stores had to close down, the tenant, the debtor trying to restructure, as long as it aided in the restructuring, was not illegal and was fair to all creditors in general. It doesn't matter that it might be unfair to landlords, but it has to be fair to all creditors in general. One of the tests is, does this restructuring have a good likelihood of being successful and therefore maintaining jobs? That is really the test. Under the Companies Creditors Arrangement Act, landlords could also be stymied in this way, because the Companies Creditors Arrangement Act also gives judges wide latitude in the cases that they are overseeing. And their considerations are very much the same. Does the restructuring have a good chance of success? And is what is being asked that I approve not illegal? And as a whole, on balance, is it fair to all creditors? So could this tactic be used in Canada to help ward off overly aggressive and unreasonable landlords for a corporate restructuring? We believe it can be. We don't know any case where it's been tested yet, but certainly there have been rulings on different kinds of agreements, and the courts have said for overly aggressive and unreasonable creditors, the company trying to restructure does not have to live up to the terms of the agreement for the time being. The court was very careful to say the requirements are not being waived, and it's without prejudice for this creditor to come back to court later to claim everything that's owed and to try to seek other relief. But for now, the stay of proceedings prevents them. So again, I hope that you and your family are safe and healthy. SmithTrustee and Receiver Inc. is open. We are doing consultations by telephone and video meeting, and we are here to answer any questions you may have. And if you have any questions or comments about this video or the blog, please shoot either Brandon or I a message or give us a phone call. Stay safe, stay healthy.